The following is an example of how trials and cases go within The Hague. In 2003, the UN Special Court for Sierra Leone, or the SCSL, indicted the then President of Liberia, Charles Taylor, for 17 counts of alleged war crimes for supporting rebels in Nigeria who caused many atrocities. The President, however, escaped into exile in Nigeria after an arrest warrant was placed on him. In early 2006, Nigeria asked for a trial against a Mr. Taylor to occur in The Hague. In April 3, 2006, Charles Taylor stood in front of the SCSL and pleaded not guilty. On June 20, 2006, Taylor was transferred over to The Hague, and then a year later, on June 4, 2007, the trial began with the prosecution's opening statement. However, Taylor refused to show up since his defense lawyers were given insufficient time to prepare. Starting in January 7, 2008, the trial picked up again as the prosecution started calling witnesses. This process kept on going until February 27, 2009, and during this time, Taylor's lawyers appeared in court. On April 7, 2009, Taylor's lawyers made a submission of no case to answer or motion for judgment of acquittal. This means that the prosecutors had failed to prove Taylor's guilt. However, on May 4, 2009, the trial chamber dismissed these claims that the defense had made. On July 13, 2009, the defense opened with a statement from Taylor's lawyer, Courtney Griffiths. He said that his client is not guilty of the charges against him. He also then raised some interesting points about The Hague itself and this trial. Charles Taylor's defense brought up a good point in asking the question, why isn't Gaddafi also on trial? Gaddafi happens to be the president of Liberia who took over after Taylor's leave of office. Then, Taylor's lawyer, Griffiths, has been quoted for saying that the court would have been refused funding by the British government had they attempted to indict Gaddafi, because the British government, led by Tony Blair, were anxious to pursue their economic interest in that country, the country of Liberia. The defense then went on to say that this entire trial was a politically motivated conspiracy by Western nations. Griffith was then again quoted for saying that it is to the shame of the prosecution that this case was besmirched by the lofty ideals of international criminal law by turning this case into a 21st century form of neo-colonialism. Also on July 13, 2009, Charles Taylor took to the stands. After many days of testimony, he denied having any knowledge of the RUF rebels in Sierra Leone. He then accused The Hague of making connections to him and the rebels. On November 10, 2009, cross-examination began, and during this time, there were leaks of the U.S. diplomatic cables by WikiLeaks, and this showed to the defense that this case and trial was so unprofessional. There was a quote that says that this was not a trial at all, and it just shows how it was just a political prosecution. On February 19, 2010, Charles Taylor concluded his testimony as a witness. On June 20, 2010, the prosecution reopened their case with permission of the trial chamber. On August 5, 2010, supermodel Naomi Campbell testified as the prosecution's 92nd witness. The defense had to claim that because of the supermodel taking part in this trial, that is when the trial actually gained international attention. On November 12, 2010, the defense rested. On February 8, 2011, prosecution presented its closing arguments. And then on March 8, 2011, defense presented its closing arguments. And then on March 11, 2011, judges finally closed the trial after 3.5 years. And then, coming up on September 2011, or around there, judgment is to be expected. What will it be? Will he be guilty, or will he be not guilty? It's really up to The Hague to decide. But should it be?